Welcome to the Miller Report Real Clear Journalism. I'm Maggie Miller. The Supreme Court issued a major ruling, one that President Trump quickly declared a giant win. But as Real Clear Investigations' Ben Weingarten reports, that victory may be more symbolic than substantive. In a 6-3 decision in CASA versus Trump, the court said that the lower courts had likely overstepped by issuing universal injunctions. Those are orders that block a president's policy nationwide, even for people not involved in the case. Trump called it a blow to his opponent's most potent legal weapon. But the ruling left a backdoor wide open. Within days, opponents filed class action lawsuits, a legal strategy that essentially recreates universal relief under a different name. In New Hampshire, a group sued on behalf of a nationwide class, opposing Trump's executive order on birthright citizenship. Judge Randolph Moss even certified a class covering everyone affected by Trump's asylum restrictions. Justice Samuel Alito warned that this could make the court's decision moot, cautioning that the universal injunction will return from the grave under the guise of nationwide class relief. Legal experts like Stanford's Mila Sohani agrees, saying that the court may have done little more than hand the executive branch a short-lived litigation win. And that's not the only workaround. Courts can still act using third-party standings for states or the Administrative Procedure Act, which allows judges to set aside agency action. In response, Senator Chuck Grassley has introduced the Judicial Relief Clarification Act to close these loopholes and stop what some see as end runs around the court's ruling. The bottom line, while the Supreme Court may have tried to limit universal injunctions, the legal battlefield has already shifted and the fight over executive authority is far from over. I'm joined now by the lead investigator on the story, Ben Weingarten. Ben, thanks so much for being here.
Thanks for having me.
So you mentioned how quickly challengers pivoted to class action suits. So what, if any, safeguards exist to prevent these lawsuits from becoming just a backdoor to universal injunctions?
Well, really, the key when it comes to ensuring that class actions are legitimate and they don't allow plaintiffs to, in dubious fashion, potentially seek universal injunctions just under another form, is that, at least as the several Supreme Court justices argued, that federal judges in the district courts at the trial level and then beyond, and that includes obviously at the appellate level, rigorously ensure that the thresholds for bringing class action lawsuits are met, and essentially that once again, judges don't allow plaintiffs to essentially overstep their own bounds. And there are several different criteria that plaintiffs trying to bring a class action suit must achieve in order to be certified as a class and then to seek a remedy like an injunction to protect them, to prohibit the enforcement of a policy, etc. And so what it comes down to then ultimately is, will judges ensure that those bars are high? Will they require in their analysis that plaintiffs provide substantial justification? This is one of the things that those who dissented from the CASA decision on birthright citizenship / universal injunctions lamented. They said, well, to get class certification is a high bar. There may be discovery. There may be a substantial back and forth and briefing at trial, and you need to present this rigorous analysis. And the sort of inference was that this was going to be a deterrent potentially to plaintiffs who might not have the means or the resources, the time, the energy to go about bringing class action lawsuits on behalf of potentially people all across the country, if not outside the country, potentially in some of these immigration cases. But that has not proven the case, at least in a couple of immigration-related cases, including one pertaining to birthright citizenship, which was at the heart of the CASA case. The plaintiffs have been able to assemble their classes, make their case that they deserve class certification, and lower court judges have seen fit in a couple of instances to certify those classes. Whether or not that's justifiable is yet to be determined. One of the other hurdles for those seeking class action suits and then to receive relief that might effectively take the form of a universal injunction is that you can have an interlocutory judgment, which means that you can challenge whether that class was justifiably certified well before you hit the end of a case. So you're going to see appeals likely in many of these class action suits to come, challenging class certification. That'll get adjudicated, and that obviously adds time and cost, et cetera. So that is potentially a deterrent, but not to the extent that the plaintiffs have legal counsel, either have the means or have legal counsel that are going to work pro bono and see these cases through.
Yeah, it didn't seem like the justices' messages were necessarily heeded. So it does seem like we are probably heading towards more litigation. Do you see any potential for intervention from Congress? Where do you see this going next? Where do you see this fight?
Well, I think it's probably going to start with what appeals courts do when some of these class actions, when the class certification decisions are challenged. And I think you're basically going to see a lot of litigation at the lower court levels, and ultimately it's going to quickly percolate up to the Supreme Court and across a whole raft of different alternatives that plaintiffs are going to pursue to try and halt administration policies. You're going to see litigation in courts all over the country. At the trial court levels, you're going to get different decisions based upon the jurisdictions and who the judges are. At the appellate levels, certainly you're going to see a raft of differing decisions, and then ultimately they're going to percolate up to the Supreme Court. And really, the question is going to be at the end of the day, as I lay it out in this piece, there's sort of a few different alternatives that plaintiffs might pursue. There's the class action suit, where the class is basically anyone and everyone who might be affected by a policy, and you're going to seek an injunction to protect that class, which looks like a universal injunction. You may see as well plaintiffs appeal to states to represent them and claim what's referred to as third party standing. So the state will essentially seek an injunction on behalf of effectively all their citizens, or the percentage of their citizens or residents, maybe not even citizens, who are impacted by a policy. So one of the things that some of the justices are concerned about is that, well, is it legitimate for a state to claim the interests of its people are affected, and so it's going to represent everyone within a state's borders? Another aspect is this notion that the court raised that lower courts may help put forth remedies that provide complete relief between the parties. How do you define complete relief, and how is that interpreted? Is complete relief going to be interpreted as, well, the only way to provide complete relief is to essentially enforce a universal injunction? And then last but not least, something else that's raised in the CASA decision is this notion of vacatur under the Administrative Procedures Act, where essentially some courts have interpreted it to say that if you put forth a rule or regulation that doesn't pass the strictures of the Administrative Procedures Act, then the court can hold it to be unlawful and set it aside, essentially giving the same kind of relief. You're not able to enforce or not enforce a policy, depending upon the policy put forth. In all of these different cases, you're going to see plaintiffs try and push and prod and test to see what is the most efficacious path to get the result they want in court. Appellate courts are going to rule, and then we're going to see whether the Supreme Court is going to rule on the merits solely of the individual cases, or if, like with universal injunctions, at a certain point they're going to argue that these remedies are being abused, or judges at the lower court levels are not rigorously adhering to the standards you're supposed to put forth, like we talked about on class actions. And the Supreme Court will ultimately say or advise the lower courts that they should interpret these different measures accordingly and call for limitations on them. But that said, to your point about does Congress get involved, ultimately Congress created the lower courts. Congress can abolish the lower courts. Congress can put limits on any and all of these remedies. And so to the extent there's a perception that they are getting abused, as universal injunctions were being arguably abused in the eyes of many in Congress, and as Congress sought to curtail universal injunctions, but ultimately the Supreme Court stepped in, you may well see legislation that might match the kinds of limitations that the Supreme Court would likely advocate for.
Took the words right out of my mouth. I was going to ask you about all those workarounds, and you covered them all. So I did want to also touch on forum shopping. which obviously is something you and I had spoken about in the past when we were discussing universal injunctions. Did this Supreme Court decision do anything to address that, or is this still mainly an unresolved issue?
It's not clear that the Supreme Court's decision will not prohibit, but will deter plaintiffs from seeking to bring cases in jurisdictions that they think are going to give them the most favorable outcome or increase the odds of giving them their most favorable outcome. One thing the Supreme Court decision did was, to the extent plaintiffs are seeking an injunction and the lower courts are not going to impose universal injunctions, that neutralizes to some extent the benefit of the forum shopping, because basically you're going to seek an injunction in a court. That court will prohibit potentially an activity with respect to you, but not non-parties. Now, it may well be that some courts will say, well, we believe that to provide relief here, our relief is going to protect you and then everyone else in our jurisdiction. But that only means in essentially the geographic area, the legal jurisdiction that that judge is presiding over. Or in other words, another way we might look at this is they might make a judge might make a decision within their district, and that decision will effectively serve as precedent in the district. So when others bring those claims, they'll get the protection of a similar injunction. And then it may well be that an appellate court might make a ruling that could cover maybe a broader area, maybe not. But at the end of the day, it limits the reach. So the impact of a ruling, at least as I understand it as a non-lawyer, is likely going to be more limited on injunctions with respect to individual plaintiffs. But obviously, to the extent you're able to find a judge who is likely to certify a class which constitutes everyone under the sun, you're going to be left with the same potential outcome. And so the incentives are all going to be on the side of, as a plaintiff, trying to bring a case in a place where you're likely to get a judge who is going to certify the class that you think ought to be certified. So you're still going to have strategic targeting of various courts. The court's rulings might have more limited effect, but the strategy is still definitely going to be on the table. And there are ways that you might curtail this. In, let's say, for example, you might require that if you're challenging an executive order, a three-judge panel randomized with three district judges from all over the country might be the ones to decide. Or there might be an immediate appeal that goes to a three-judge panel that consists of three judges from all over the country. So there's been chatter when it came to universal injunctions about what about appeal to a panel, or what about a panel initially, that might mitigate the idea of forum shopping and trying to game the system. But as of yet, we're not there.
So, just building off of that a little bit, Justice Alito warned about a too lax approach to class certification. So, how consistent or inconsistent might we expect these rulings to be?
So one of the things that we cited in this report is that when class actions have been brought to challenge federal policies, the plaintiffs have been pretty successful at garnering certification historically. So that, whether or not that speaks to rigor or lack of rigor in the way that judges are looking at the thresholds for obtaining class certification and applying them and then seeing whether the plaintiffs meet them or not, is obviously going to be open for debate. And I'm sure we're going to see tons of reportage about the merits or demerits of classes seeking certification going forward. I think we have to take a wait and see approach to evaluate what jurisdictions and what judges in particular take what approaches with respect to class actions. These are also sort of unique when you're challenging a federal policy and seeking to do so as a class, in that typically when we think about class action lawsuits, we're talking about claims. Someone was hurt by a company or claims to be hurt by a company, et cetera, and they're seeking some kind of monetary damages and a settlement. In this case, the cases are different. You're claiming that you're going to be irreparably harmed, or there's a good chance you can win on the merits before courts. that you are irreparably harmed by a policy. So it may well be that the thresholds are applied differently because the nature of the cases being brought are different as well. That's my speculation on it. We have to see, but historically, classes have achieved certification, favorable rulings at a pretty high rate when it comes to challenging federal policies. And that may well be precisely why, or in part, Justice Alito and others on the court are concerned about the potential abuse of class action because the thresholds have been met at a pretty high rate historically in cases like the kinds likely coming in challenges to presidential policies.
So, Ben, what would you like to leave people with? Where are your sights set with regards to universal injunctions?
Yeah, so I think ultimately the question is going to be, are we going to see plaintiffs en masse seeking class actions immediately, or are they going to continue to try and pursue injunctions and claim that they need relief, that to obtain complete relief, they ought to get what amount to universal injunctions or injunctions providing relief for very broad segments of the population. I also think that the third party standing and using states to represent everyone who resides within their borders potentially, that is likely to be a path that is pursued, particularly when you're talking about immigration cases, which obviously deal with travel across state lines. Oftentimes, you're definitely going to see states, just as in the birthright citizenship context, because in at least one or two of the cases that formed the CASA case, that were consolidated in the CASA case before the Supreme Court, you had states who were the plaintiffs. If you have policies that plaintiffs disagree with in a handful of different states, why wouldn't you bring suit and have several states represent everyone within their borders? And then essentially you try to get relief representing all those states and get de facto universal relief that way. Those are definitely going to be paths that I think are pursued, and we'll have to see how quickly those cases come together and what policies they're challenging. And then last but not least, to the extent the administration is able to get to the devising associated rules and regulations, we're definitely going to see a lot of Administrative Procedures Act challenges, I suspect. Will Congress step in is definitely a major question. And then again, I go back to, will the Supreme Court aggressively intervene as the lower courts deal with these questions, or are they going to let a substantial number of cases on the limitations and the rigors, the application of all these different thresholds? Are they going to let the lower courts fight it out, see where the appellate courts go, and then when you have differences at the appellate court level, is the Supreme Court going to step in, or is it going to intervene far sooner? These are open questions, and we'll have to see where they go. But this is one of the reasons why, as we said in the piece, the suggestion essentially is that the curtailing of universal injunctions was probably just the end of the beginning when it comes to the fight between not just Trump and Trump's foes on the legal side, but presidential power versus the power of these plaintiffs, and then, of course, the executive branch versus the judiciary. These battles are going to continue. They're probably going to manifest themselves under Democrat and Republican administrations alike. And so that was one of the reasons we wanted to put forth this story now in anticipation of major battles of public importance that are likely to come.
It does sound like it's just the beginning. Well, Ben, thank you so much for your time.
Thank you.
That was it for the Miller Report, Real Clear Journalism. I'm Maggie Miller. I'll see you next time.